Hi, good afternoon, everybody. My name is Alexander Rufus Isaacs, also known as Zan. I am the second vice president of the Beverly Hills Bar Association, and I've been helping put together the BHBA's Community Legal Clinic, together with my colleagues on the committee, Maggie Stewart and Martin Berman. And I'd also like to thank our executive director, Belinda McCauley, and our president, Adam Siegel, who've been very instrumental in helping us put this together, and also David Daniels, who is the chair of Pro Bono at Public Counsel. Today is the first of two programs which are designed to prepare volunteers to handle cases in our ticket dismissal program. Today's program is very much the nuts and bolts. Rachel is going to explain to you how you handle these cases and provide you with templates for the documents that are going to be used. And the second program is going to be on August 12th, when there's going to be more of a preparation for what sort of people you're going to be representing. Amy Brasher and Alfred Lomas of Inner City Visions are going to be providing what we refer to as cultural humility training, which is to prepare volunteers for the fact that the people that we're going to be representing are probably not like the normal clients that we represent. And it's important that everybody please attends both of these so that we're properly prepared to go into this program. In order to become a volunteer, we do need your details. So as well as attending the two programs, we ask you to please click on the link that should have appeared in the chat function here and complete the information form that has your details. And so you'll then be a fully qualified volunteer, and we will be in a few weeks' time starting the flow of cases from Inner City Visions and also from Public Counsel, and we will then be handling cases and we'll be going live, and it'll be your boots on the ground. It's fine to ask questions. Please use the chat function as we go, and I will be reading the questions as we go along and putting the questions to Rachel. And finally, it's my great pleasure to introduce to you your instructor for today, Rachel Stein. Rachel is the supervising attorney for the Transition Age Youth, which is TAY, program at Public Counsel. The TAY program provides legal and social work services to young people who are currently or formerly system involved to ensure that they have access to housing, education, benefits, healthcare, and fundamental rights. Rachel also has experience in the area of dependency, adoptions, public benefits advocacy, and employment law. She holds a JD from the University of Michigan Law School, an MSW from the University of Michigan School of Social Work, and a BA from Swarthmore College. Prior to her youth advocacy work, Rachel practiced employment litigation at Munger, and Olson, and also at Fox Group Legal. So with that, it gives me great pleasure to introduce Rachel, who is going to instruct you on the ins and outs of ticket dismissal cases. Thank you.
Thank you so much, Zan. It's really nice to be here. Thank you all for participating today. It's always exciting to get assistance from attorneys in the community. We always receive more referrals than people we can help. And so getting your assistance on these matters is a huge benefit to our clients. So as I mentioned, Public Counsel provides direct legal services to low-income residents in LA County, and we have strong partnerships with pro bono firms and with volunteers. That's a major component of Public Counsel are these relationships. And within our Transition Age Youth team, we provide these various types of direct services to young people who are system impacted. And by that, we mean that they are currently or were formerly in foster care in LA County. And they could be in foster care either through the dependency court or through the delinquency court. So our clients are particularly vulnerable to traffic stops and to getting tickets for various reasons. One of the factors is that they're often young people of color who are driving in over-policed neighborhoods. They often have inexpensive vehicles that may have visible defects like a cracked windshield or a broken taillight that make them more susceptible to being stopped. And when they are stopped, they often lack the money and support necessary to have a lawful license and car registration and car insurance. So this is a really important aspect of our work, is trying to get these tickets dismissed. We do only handle certain types of ticket matters. So we only assist on infractions, which is the lowest level of offense that you can be charged with. We do not provide representation on misdemeanors, because those are criminal matters, and the public defender's office generally is able to provide representation to our clients on misdemeanor matters. We also only handle tickets issued in LA County. We don't work outside of LA County, and we do not handle parking tickets. So the impact of getting these tickets dismissed can't be understated. What we're doing is we're removing barriers to independence for our clients by making it easier for them to travel to attend school, work, and important appointments. Many job opportunities are restricted to people that have a valid license. So getting these tickets dismissed is a real benefit to our clients in many ways. It also helps them avoid a stressful court appearance, because we're able to appear on our client's behalf in court, so they don't have to make their own appearance. And getting these tickets dismissed protects them from having to pay really high fines and fees that they cannot afford to pay. They're able to avoid the need to attend traffic school, to do community service. They're able to avoid points on their driving record. And even if we're not always able to get dismissal, we still may be able to get a really good result for our client, in that we can sometimes get the fine suspended or reduced if we're not able to get the court to dismiss the ticket in its entirety. As Anne mentioned, I'm going to take you through kind of the nuts and bolts of how to work on one of these ticket cases. We'll start by talking about scheduling the ticket. Then we'll talk about the importance of identifying any potentially correctable offenses, preparing the papers that you will file with the traffic court, and then the arraignment hearing, and finally the trial, if you're not able to get the matter dismissed at arraignment. So before we send you a case, we do an intake process. And so the cases are referred to us from various different sources. And when we get the case, we do our own conflicts check, and then we try to gather information from the client about the ticket. That we try to get the ticket number, the date of issuance, the law enforcement agency that issued the ticket, and any background information the client has about the ticket. So that way, when we are assigning a case to you, we'll be able to give you at least the basic information about the ticket and about the law enforcement agency that issued it, so that you can run your own conflicts check. The clients often don't have a copy of their tickets, but if they know their state ID number or their driver's license number, you can look up their tickets on the LA Superior Court website just by entering their ID number and their date of birth. So this is an image of the information you can get from the court website. It doesn't tell you the particular offense that they were charged with, but it tells you the ticket number, the court where it's pending, what law enforcement agency issued it, the violation date, and the status, meaning is the ticket past due, or is it still open and the due date has not passed yet. So step one, after you've signed the retainer and you're ready to start working on the case, is to schedule the ticket for the arraignment hearing, which is the first hearing in the matter. So you're going to call the traffic court clerk at the courthouse where the client's ticket is pending, and we can give you a list of all the different phone numbers for the different traffic court clerks throughout LA County. And so you'll want to call and tell the clerk that you are the attorney of record for that matter, and you'd like to schedule the ticket for an arraignment hearing. It's also a good idea to confirm with the clerk whether the client has any other tickets that are showing up, just to make sure there aren't additional ones that we didn't know about. And then you'll want to ask the clerk for information about the vehicle code sections that they were charged with violating, the date of citation, the citing agency, the amount due, any information that we weren't able to gather during the intake process. You'll want to try to gather that from the clerk. Also, just a good idea to double check the information we got from the client with the court clerk. and then you'll ask the clerk to list you and your firm as attorney of record, and then you'll want to ask them to mail you a copy, a physical copy of the citation. You don't necessarily need to have a copy of it, but it's useful to have that information. It's a good idea after you've scheduled the ticket to send the clerk a letter informing them that you're the attorney of record and asking them to mail you the citation and any correspondence regarding the matter. We have a sample letter to the clerk that we'll include in your template documents. Okay, so something to note about overdue tickets. Many of our clients, by the time their cases refer to us, they've already missed the deadline for resolving the ticket or paying the fines. So in that case, they're going to be charged with, in addition to the underlying infraction, they're going to be charged with what's called a failure to appear, which is an additional charge, and it carries additional fines. But even if their ticket is past due or overdue, they still have the right to schedule their ticket to be heard in court, even if it's been in collections for years. And now, as a result of the pandemic, LA County has agreed to list a failure to appear license suspension upon scheduling an arraignment rather than upon appearance. So it used to be that you could not get the hold on your license lifted due to a failure to appear until you showed up at arraignment. But now, as soon as you schedule the matter for an arraignment hearing, the clerk should contact the DMV, and then the DMV should lift the hold on the license if that ticket is the only reason there's a hold on the license. So when you do schedule the ticket, you do want to make sure that the clerk is, intending to send notice to the DMV, to lift the hold on the license. And then something else you can do maybe about a week after you schedule the ticket for hearing is you can call the DMV mandatory action line yourself to confirm that the client can lawfully drive, or you could give that information to your client and have them call the DMV and confirm that the hold on their license has been lifted. Okay. So after you've scheduled the ticket for hearing, you do want to start to identify, potential defenses that you'll be able to raise for your client. And one of the, most obvious types of defenses you can raise is any correctables. If your client's ticket is capable of being corrected, not every citation has something that can be corrected. And sometimes our clients just were not able to correct the issue for various reasons. But the types of citations that could theoretically be corrected are driving without a license, driving without registration, minor vehicle defects like a cracked windshield, a broken tail light. So if they're able to, get their license reinstated, get up-to-date registration, fix the vehicle defect before the arraignment, that's definitely something you'd want to raise in your papers and provide proof of that correction. Driving without insurance is usually not correctable, but if the client does get insurance after the fact, it's still a good idea to bring proof of that insurance to court and to mention that in your papers. So some of the common barriers to getting certain infractions corrected are that the client might have already sold the car or lost the car because of a tow. Maybe it wasn't their car, maybe it was a friend's car. This is actually fairly common. So they're not in a position to try to, fix the windshield, for example. They might not be able to afford registration or insurance. All of our clients are low income, and that's something we screen for at the outset of the case. So it's not uncommon that they wouldn't be able to afford to get insurance. So even if you're not able to correct a citation that's theoretically correctable, you can still move forward with dismissal. It's just going to be, easier if the client was able to correct the issue.
Rachel, to
yes.
interrupt you for a minute, we have a question which is regarding correctables. Do you have to show that the client had a valid license or registration at the time of the ticket or at the time of arraignment?
You have to show that it's at the time of arraignment. So even if they didn't have it at the time, if they're able to show that they corrected the issue after the fact, that can still be a basis for asking for the lower fine associated with correction. So like if my client, had a broken windshield and was at the time of the citation, that's why she was cited, but she was able to correct that after the fact, and I can provide proof of that, that would be, valid proof of correction.
Great, thank you.
Sure. And so, if you are able to show that the client corrected the issue, it should be a $25 dismissal fee instead of the much higher fees normally associated with these types of infractions. But you still would want to, see if you could get that waived or suspended. Okay. So in the papers that we file in these matters, we call them 1385 requests. What we're doing is we're seeking dismissal and furtherance of justice under Penal Code Section 1385. Defendants in these matters are not permitted to file a formal motion seeking dismissal under the statute, but they can informally make this request. And they can do that by way of a submission that's supported by a declaration. So we call them 1385 motions, but they're not really motions. They're, sort of informal written requests to the court. So we always, we'll cite to Penal Code Section 1385, and in the template request that I'll share with you, or they may already have, it cites to that authority. The other legal authority that we raise in our papers is California Rule of Court 4.335, ability to pay. And so that rule says that a defendant may request an ability to pay determination while the judgment remains unpaid, and that the court can exercise its discretion to provide for payment on an installment plan, to suspend the fine in whole or in part, or to offer some type of alternative disposition. So, I mean, the best result we can possibly get would be a complete dismissal of the ticket and a suspension of all fines and fees. And that, in that case, we wouldn't have to worry about, getting the court to reduce the fines based on ability to pay. But if the court's not willing to dismiss in the entirety, then as an alternative, they may be willing to reduce the fines and fees based on our client's ability to pay. So there's a potential new argument that we can also add to our 1385 submissions. And actually, I want to give credit to another pro bono attorney who attended our training that we did for the Santa Monica Bar Association. And she's handling a case now for us. And she, mentioned that she was including this new argument in her written submission, which is that dismissal will further the state policy of eliminating ticket debt for low-income Californians. You may be aware that the governor's 2022 budget that was recently signed is really broad in scope and has a lot of progressive features to it, including guaranteed basic income pilot program. And so another one of the things in the budget is that it's supposed to eliminate debt for traffic fees and fines for low-income Californians regarding tickets incurred between 2015 and June 2021. The Judicial Council is going to determine the eligibility criteria for that program. And as I mentioned, all of our clients are screened at intake to confirm they are low income. And by that, we mean they either qualify for a means-tested government benefits like CalWorks or CalFresh, which used to be known as food stamps, or SSI benefits. So either they qualify for one of those means-tested benefits, or their income is 125% or less of the current federal poverty rate for household size. So all of our clients are low income, but it's not clear if they would qualify for this new debt forgiveness program, or even how they would access the program, because it's still very new. And I'm not even sure if the Judicial Council has confirmed what the eligibility criteria are at this point. But even if we don't know our clients would qualify for this program, we can still make the argument that it evidences a state policy of eliminating debt for low-income people. So I do think it's a good idea to include this. And this is not in your template document that I sent you, so you'll want to, if you would like to include it, you need to add it. Any questions about that? Okay. All right. So moving on to preparing the papers. So our practice, as I mentioned, is to draft a written request for dismissal, and then we always include a client declaration as Exhibit A. So before you prepare the papers, you'll want to interview your client to gather information to support this request. And so, and the types of questions you'll want to be asking your client relate to the furtherance of justice, different factors regarding their life and their experience and their current challenges that make dismissal appropriate and in furtherance of justice. Okay, next slide, please. So some of the information that you'll want to try to gather from your clients relate to their foster care history and status. All of our clients, as I mentioned, are system impacted, so they were either current or former foster youth. And I do think that that's, valuable information to include in the declaration, because along with being in foster care comes a lot of other challenges, which I'm sure you're aware. Often our clients have experienced a fair amount of trauma, a lot of upheaval, a lot of different placement changes, as they move from foster home to foster home. And so that all can contribute to, factors that make them susceptible to the ticket, and also make them, particularly vulnerable to the impact of these types of tickets. So you'd want to also ask about homelessness and if they have unstable housing, not only now, but at the time of the ticket, if they are employed or in school, what their finances are like, and if they are receiving means-tested benefits, if they have any dependents that they're responsible for, if COVID-19 has impacted them financially or in terms of their health, their disability status, any health setbacks they're facing, what their goals are, if they have an upward trajectory, maybe their goal is to graduate from this vocational program they're in, to become a nurse or nurse's assistant, how the ticket is preventing their progress in achieving independence and stability, and also just any extenuating circumstances surrounding the citation. So for example, if a client was homeless at the time they got the citation, and maybe that's part of the reason they didn't get the notice, that could be one factor explaining why they have a failure to appear. I mean, that's not a legal defense, but certainly, I think that's relevant information. And then if they aren't, and then if it is a correctable, you want to ask about, did they correct it? Are they able to? Why or why not? All of that is helpful information. All right, great. So these are this is an example declaration, and we will definitely include this in the template documents that you'll have access to. I should also mention that even though we assign you the case in the beginning and it's your case, I'm completely available to provide you with technical assistance and support and answer any questions you have throughout the life of the case. And I'd be happy to review your draft papers if that would be helpful to you. Next slide, please. So let's say that you've interviewed your clients, you've gathered the necessary information, and now you're ready to prepare the papers. You also want to consider whether, in addition to the declaration, you might want to attach other exhibits that could be helpful, such as evidence of benefits enrollment. As I mentioned, if your client is getting means-tested benefits, that's a sign that they are low income. So if they have proof of getting those benefits, that could be helpful to include. If they have a letter from an involved social worker, employer, or someone else in their life who would be willing to write a letter regarding the services they're in or just the progress they've made in services, that could be helpful, although definitely not required. Sometimes and actually in our template, I think we have a reference to an article or study regarding just the challenges that current and former foster youth face. And so if you wanted to include information for the judge's edification about that, you could include that. And then of course, if it is a correctable and you have proof of correction, you'd want to include that. But none of these things are necessary. We often are able to obtain dismissal just through the 1385 submission and a supporting declaration. But if you do have, some other evidence that would be helpful to include, by all means do that. And one other thing I should have mentioned in terms of, the interview process, obviously these are sensitive topics that you're asking the client about. So, I mean, and I'm sure, probably in your other training, this issue might be addressed about, talking to clients who've experienced trauma and how to do that. I mean, what I personally do is, explain the reason I'm asking for this, that I know this is sensitive information, but the reason I'm asking is because it may help us increase the chances that their ticket will get dismissed. And I also, am clear with them that if there's anything they don't want to include in the declaration that's too private or sensitive, of course we don't have to. So even though I ask them about medical issues they're facing, or maybe they have mental health issues that have impacted their ability to get the ticket resolved, if they don't want to share that with the court, of course they don't have to. So it's really entirely up to them, whatever they feel comfortable including in the declaration. All right. So if some clients are working towards getting a degree, sometimes we attach a study showing that only 3% of foster youth get their 4-year degree. So that's actually, a huge accomplishment. And for our clients who are at risk of homelessness, which is many of them, we often include statistics about how many foster youth in LA age out into homelessness, which is an unfortunate reality. Arraignments. So there are, up to 2 hearings involved in these matters. The first one is the arraignment, where you'll have the opportunity to seek dismissal. And if the court is not willing to dismiss, then you would need to enter a plea for your client. So you can attend arraignment remotely if you like through Court Connect. You obviously need to schedule that in advance, but that is certainly an option. I have had some technical challenges in doing that. I find that the technology is not great, and sometimes the clerks have trouble maneuvering it. One time, the clerk had a lot of trouble taking me off mute. So I personally prefer to appear in person, but I understand why some people might, definitely feel more comfortable appearing remotely, and that's certainly an option for the arraignment. If you're going to appear remotely, then you want to make sure you submit your 1385 to the court, well in advance of the hearing. You can either drop it off in the drop boxes outside the traffic court, or you can have it filed if you'd like. If you do want to file in advance, your client should qualify for a fee waiver. But even if you file ahead of time and then you want to show up in person, you always want to bring copies to the hearing. You want to bring copies for the court and also for potentially, the police officer if they show up. I always bring, a business card with me, even if I, think I've been assigned as attorney of record. And you might, this is not uncommon, that they will, instead of having a judge or magistrate, they'll have a pro tem, and then they ask if you will consent to that. I think all things being equal, we prefer to be in front of a judge, but I've also gotten very good results in front of pro tems. And so it's really up to you, whatever you feel comfortable with. But if you do want to wait for a pro tem, they're probably going to assign you to a different courtroom, and it might take longer to get called.
Rachel, we
yes.
have another question. Does the client have to attend the arraignment?
No, absolutely not. The client does not have to attend. You are able to appear on their behalf, and you're able to do that because of Penal Code Section 977A. So when you are appearing, if your client is not going to appear with you, you do want to clarify that you're appearing pursuant to Penal Code Section 977A, which allows you to appear on your client's behalf.
Great, thank you.
Sure. So you'll state your appearance, you'll present, I would usually, confirm that the court has already received my submission if I filed it in advance. If I gave it to the clerk that morning, I alert the clerk that I've submitted this informal written request, and then I offer to provide additional information about the request and to answer any questions the judge might have about it. And, a lot of times the judge will grant the request. It really depends on the judge. We don't always have success at the arraignment stage, but, I would say more often than not, we are able to get the matter dismissed at arraignment based on our request for dismissal. But sometimes, depending on the judge, they might not be willing to do that. And in that case, it's our practice to enter a not guilty plea for the client and then set the matter for trial. The judge may try to offer you different types of pleas and different types, because that's normally what happens at arraignment, is that the court is offering people a lesser sentence and fines in exchange for a guilty plea. So it's not our practice to accept any of those. One problem is we don't know what the judge is going to offer in advance. The client often would rather not be there, so we're not able to confer with them about the offer. So it's just typically our process to enter the not guilty plea and then prepare for trial.
Rachel, we have another
Yes.
question.
Yes.
Is it generally preferable to file a 1385 in advance, or is it okay to bring it with you to the appearance with some copies?
I found that it's perfectly fine to bring it with me. One problem with filing it in advance is that sometimes they reassign you to a different courtroom at the last minute. So even if you file it, it might not get to the right judge when you show up the day of the hearing. So I do try to get there, before my hearing is supposed to be called, so I can give copies to the clerk and make sure they have time to give it to the judge before my case is called, so the judge may have a little time to review. But if you, theoretically, it is possible to submit it and file in advance. And actually, we have a case recently with a pro bono attorney who filed her 1385 in advance, and the judge actually took it off calendar based on her filing, which we hope and expect means the judge is probably going to grant the request on the papers. So, that is maybe one reason why you'd want to file in advance. But you can't assume that the right judge got it just because you filed in advance. You absolutely would want to bring copies anyway, and then confirm, with the clerk whether the court has received it already.
You have two other questions.
Yes.
First one is, assuming the judge does not dismiss the matter at the arraignment, do we have authority to take a lesser charge with no fines and fees?
You would definitely have to discuss that with your client, in advance. And so, if you had discussed it with your client and you had authorization to do that, then yes, I would say, you could. So yeah, that's probably worth, having that discussion. It really just depends on the judge, what they're willing to offer. But often what I've seen is if they're offering something, less than dismissal, it's not a suspension of all fines and fees. It's, some amount of payment that the client is expected to make.
The second question is, how often is the oral request for dismissal granted?
So I'd say, I don't have percentages, but I guess in the cases I've done, I'd say at least more than half the time, the request is granted. And by oral request, I think you mean I've submitted the written submission, and then in addition, I make my appearance and offer additional, an oral presentation regarding my request. Like, usually I'll give a brief summary, of what's in the written request if the judge would like to hear that. But yeah, I'd say, more than half the time, the judge is willing to dismiss at arraignment based on my submission and my oral presentation to the court.
Great. We have one more question's just come in. When on calendar, will you appear at the same time as regular traffic court? Do you appear before the line of people, or are you in the line, so to speak?
It depends on the court. I think in most cases, the litigants who have counsel do get to go first. Those cases are generally called first. So yeah, typically you wouldn't have to wait for all the pro se litigants to be called, but I have had to wait through that before, because sometimes if they got the written submission that morning, they'll want to take additional time to review it. So you should definitely be prepared that you might need to wait a while.
We have another question. Mm-hmm. Beyond fines and fees, would the DMV points be a consideration as well in a case of a plea to lessers?
Absolutely, absolutely. And so, that's another, reason why And again, because it's hard to anticipate what the judge may offer at arraignment, it's our practice just to enter the not guilty plea and then, set it for trial. But then again, before trial, that's something else, you'd want to have that conversation with your client about, what type of plea they might be willing to accept. Because certainly that may come up again, at the trial.
Great, thank you.
Yes, absolutely. All right, so next slide, please. So if you do want to attend the arraignment remotely, like I said, you could absolutely do that. You would just want to make sure you submitted your document in advance, and you can create an account on the court website to make that appearance. Here it says, it is $15 to make that appearance remotely, but if you wanted, you could file a fee waiver request on behalf of your client. I could, show you how to do that. And it's very likely the fee waiver request would be granted because, as I mentioned, our clients are low income. And so that would, in that case, once the fee waiver order is entered, then your appearance fee would be waived. That it does take a little time to get fee waivers granted. So if that's something you're interested in, you should do it at the outset of the case. But if you're not planning on making a remote appearance, then it's not necessary. Okay, any other questions before we move on to the next slide? Okay, all right, next slide, please. Okay, trial. So there are no remote options available at this time for trial. So that is going to be an in-person appearance. There is something called trial by written declaration, but it's not available for tickets that are overdue. It's not available for tickets that have correctables, absent proof of correction, and you being willing to pay the $25 fee per correction. And it's just not a real exercise of trial rights. So, even though this is technically an option, it's not something we'd recommend to our clients. You are able to waive time at the arraignment. You do have the right to trial within 45 days after the arraignment, but if you would like more time, or if that's just not, convenient for your schedule to have the trial that soon, you can waive time and ask the judge to set it further out. And same thing when you call to make to set the hearing for arraignment, the clerk is, willing to work with you. And if you have a conflict, they'll offer you another date. And typically, when we call to set arraignment hearings, the first available hearing date is usually a couple months out from when we call because the courts are so backlogged. It really depends on the court, though. All right, next slide, please. So there are 3 possible ways you can win at trial. The easiest way is if the officer doesn't show up, and that happens a lot, that the officer just does not make an appearance, in which case the judge has to dismiss. Of course, you don't know that until the day of, so it's not something you can count on. You could also convince the officer before the hearing to agree with your recommendation for dismissal, or to not object to it. So it is a good idea, to get there early the day of trial, so that you can, watch out for, the officer right when they get there. I mean, so then, you're sort of in this a little bit of awkward situation where whenever someone comes in who's an officer, you ask them, oh, are you so-and-so? But once you, get the right person, you'd want to, see, explain your client's circumstances, see if they're willing to support the 1385 request, or at least not oppose it. If they're not willing to do that, you do want to ask if they have any, what their recollection is of the ticket, because that's another way to try to get dismissal, is if you can show that the officer has no independent recollection of the events, then that's another way that an argument that you could raise, and the court should also dismiss on that basis. So, if the officer agrees with you, then typically the judge will, grant your request. Or the third way is, the officer shows, they won't agree to support your 1385, and they actually testify against your client, but you're able to cross them on all elements of the statute, identify any deficiencies in their argument, maybe attack their recollection of the events to try to show that they don't really have an independent recollection. And you also, and I guess I should have started with this, you get a second bite at the apple. So, right, even though you presented the 1385 at arraignment, you can present it again at trial and see if the judge is, willing to grant it then. And often you're assigned a different judge at trial than you were at arraignment. So you are not necessarily in the situation where the same judge that denied your request is now hearing it for a second time. So, but yeah, if they're not willing to grant the dismissal on the basis of 1385, then obviously you have to proceed with the trial. We haven't had a lot of trials because usually we're able to win one of the other ways. Either the officer doesn't show, or we're able to get the judge to dismiss under 1385 at the trial. All right, let's say that you're none of those options pan out, and you do have the trial and the judge finds your client guilty. At that point, you would want to raise the ability to pay assessment and try to negotiate a lower fine. And you want to make sure that you're understanding exactly what's being offered, or what the judge is, what concessions the judge is actually making, because there are penalties that increase fines by 4 times or more. So it is important just to ask the judge exactly how much would this be total. If it's a moving violation, one option is to request traffic school. And of course, that's something you'd want to talk with your client about in advance. There is a fee for traffic school, but that's a way to remove points from your record. You should also talk to your client in advance about if they'd be willing to participate in community service, because that's something you could ask the court to order as an alternative potentially to fines and fees. A lot of people don't know this, but community service is not free. There are fees associated with doing community service, which is a reason why it's not a good option for most of our clients. But still, those fees would be lower than the cost of the ticket. So you also want to talk to your client about if they're actually physically capable of doing community service. Do they have access to transportation so they could get to a community service site? Another thing is many providers of community service are closed because of COVID. So, there aren't a lot of options in that regard, but definitely something to consider, in the eventuality that the judge does find the client guilty.
We have a question,
yes,
Rachel. With respect to your earlier explanation about the arraignment, you mentioned about talking to officers. When you mean independent recollection, do you mean independent of their own notes?
Yes, independent of their own notes, yes.
And secondly, are the officers generally okay with talking to counsel before trial, or do some of them refuse to talk?
In our experience, they are willing to talk to you. I mean, if they're also, usually willing to talk to pro se litigants as well. Because sometimes, the officer will, talk to the litigant ahead of time and then agree to, recommend something lesser than the original charge. So, in our experience, they might not always be necessarily very friendly, but they, are willing to talk to you ahead of time.
Great, thank you.
Sure. And the officer, so you're not going to have a chance at arraignment to speak with the officer. I've never had a case where they show up at arraignment. That's really just an opportunity for you to, seek dismissal, or if not, enter the plea. It's only at trial that the officer may show up. Okay. And just a few miscellaneous tips. If a client already pled to a traffic citation, or if the ticket was adjudicated in absentia, but the client can't pay the fees or complete the community service, it is possible to submit a letter to the court asking them to, dismiss in furtherance of justice. These are rarely granted, but that's another service that we provide in some circumstances. Probably the cases we would send to you would not be in that posture. We would send you cases where the ticket was where the client had not actually made an appearance. Also, discovery is available under the penal code. We're still exploring kind of the advocacy possibility related to requesting discovery, but we do have template documents if you're interested in pursuing discovery. One limitation of using that strategy is that you have to do it very quickly because everything, the timelines are very short. So if you lose at arraignment, you would have to send out the discovery shortly thereafter, and then you wouldn't be able to waive time for the trial. One other thing is sometimes citations can be charged one of two ways. The same citation could sometimes be charged as an infraction or a misdemeanor. We call those wobblers. But as I mentioned, we're trying to screen for that at the outset, and if it is a misdemeanor, it should be held in criminal court. It should not, show up at traffic court on the website. And in those cases, we would refer the client to the public defender's office. We would not, offer representation for the misdemeanor matter. Right, and I think that's actually everything I have to share. Any other questions?
No, we don't have any other questions, I believe. If anybody does, please speak now or forever hold your peace. But otherwise, I think, Rachel, you covered everything very clearly. I'm sure everybody has seen the link in the chat function to all of the materials, which includes the slides that you've been showing us today. So we have everything. And with that, I'd just like to thank you very much indeed for giving us such an interesting and easy to follow route. I would like to remind everybody that if you would like to volunteer for the program, it's essential that you do complete the volunteer form, which is in a link in the chat function. And, once we get some clients, which will be in the next few weeks, we will start allocating them to the volunteers who've attended both programs. You will have support. You'll have the ability to talk to Rachel if you have any technical issues, and also you will be assigned to someone from our committee who will be continuing to monitor each case and stay in touch with you and assist you with whatever problems may come up. And we hope very much that this is a satisfying experience, not only for the clients, but also for the attorneys. We've attempted to design a program which is not going to overwhelm the attorneys, which hopefully with the training that you've received today, you'll be able to navigate these new waters for many of us. It's exciting, it's a little challenging, but it sounds very doable. And again, Rachel, thank you very much for your assistance and your support in this. And I think, hang on, one question here just come in. Can we get a list of possible fees or fines that clients can expect to pay, like dismissal, license reinstatement, so that we can properly advise clients of the costs?
I don't have a universal list for all different types of citations, but that's definitely information you could get from the court clerk once you find out what the charge is, what penal code section or vehicle code section they're being charged with. And if you have issues with that, I can definitely help you navigate that. So we could try to figure out, what's the estimate for the total charges. So yeah, I agree. That's a good point, and it's definitely something you want to talk about with your client.
Okay, well, I think that's pretty much it. Unless we have any more questions, I don't see any more. I am going to call this webinar to a close. Again, Rachel, many thanks for everything, and thank everybody for attending. And we hope to see you out there in the courts getting tickets dismissed for this very worthy cause. Thank you.
Thank you all. Have a good afternoon.